Do you regret having the photos?
No.
You don't regret? Okay.
Why?
You don't regret having the photos?
No. Why you wanna take a photo?
Do you not regret having the photo?
Huh?
Do you regret having the photo on the phone?
You wanna make appointment with me?
No, I'm asking, do you regret having the photo on your phone?
No, I don't know what is photo in that.
Why did you have the photo?
Why? Because
What happens when a person seeking refuge from conflict is caught carrying criminal material of the most disturbing kind? A recent case in the United Kingdom has brought this complex and challenging question to the forefront, sparking a nationwide debate about justice, asylum, and the safety of the public. This is the story of Osamah Al-Haddad, a 26-year-old asylum seeker from Yemen, whose case forces us to confront the difficult intersection of humanitarian obligations and the absolute necessity of upholding the law. Stay with us as we break down the facts. Osamah Al-Haddad arrived in the UK originally on a student visa. He later claimed asylum, stating that he feared being forcibly conscripted to fight for the Houthi movement in his native Yemen, a country ravaged by a long and brutal civil war. His journey led him to London's Heathrow Airport, where, during a routine asylum screening process, immigration officials made a shocking discovery. A search of his phone revealed 3 videos containing what the court would later describe as grotesque and depraved child abuse material. One of the videos was a Category A file, the most serious classification, which involved an act of bestiality. Al-Haddad was subsequently charged and brought before Isleworth Crown Court. He admitted to 3 counts of making indecent photos of children and 1 count of making a pseudo-photograph of a child. In legal terms, making an image can include downloading or saving a file to a device. His defense was that the images were sent to him by a friend on WhatsApp, and that he had no sexual interest in children. He was represented in court and communicated through an Arabic interpreter. His defense counsel also highlighted his personal circumstances. He was working in a restaurant in Plymouth, earning approximately £781 a month, most of which he sent to his wife and child back in Yemen. He expressed hope that he could one day bring his family to live with him in the UK. The judge, Fiona Barry, was faced with a difficult sentencing decision. On one hand, she delivered a scathing assessment of the crimes. She told Al-Haddad directly, the Category A video involves an act of bestiality, which is grotesque and is depraved. You should do well to remember that this is a real child who has experienced this abuse, and those are significant aggravating factors. The judge also expressed serious doubts about his explanation, pointing to a pre-sentence report. She noted, I share the concerns of the pre-sentence report, which state that you are not entirely honest about that. You have had those videos saved since August 2021 in your possession to view and certainly not deleted by you. However, the court ultimately spared Al-Haddad a prison sentence. The stated reason was because of his fear of repercussions for refusing to fight in Yemen if he were to be returned. Instead, he was handed a 30-week sentence, suspended for 1 year. This means he will not go to jail unless he commits another offense within that year. In addition, he was ordered to perform 150 hours of unpaid work. Crucially, he was also made subject to a Sexual Harm Prevention Order, or SHPO, for a period of 10 years. A SHPO is a court order designed to protect the public from sexual harm by placing specific restrictions on an individual's behavior, which can include limits on internet use or contact with children. The verdict, and Al-Haddad's subsequent behavior, giving a thumbs up to cameras as he walked free from court, ignited a firestorm of public and media reaction. The case touches on a sensitive political nerve. Currently, UK law, as outlined by Home Secretary Yvette Cooper, includes plans to ban foreign sex offenders from gaining asylum. However, for this to apply, the offender must be sentenced to more than 1 year in prison. Al-Haddad's suspended sentence of 30 weeks falls short of this threshold. This means that, despite the convictions, his asylum application remains pending, and he is permitted to continue living and working in Plymouth. Now, Plato was fired. This case presents a profound dilemma. It forces a conversation about the principles of the justice system, where sentencing must consider both the crime and the individual circumstances, including mitigating factors like the situation in their home country. It also raises critical questions about the UK's asylum process and whether the legal framework is robust enough to protect the public from individuals who have committed serious offences. How does a society balance its duty of compassion for asylum seekers with its non-negotiable responsibility to protect children and uphold the law? The case of Osamah Al-Haddad provides no easy answers, but it serves as a stark and powerful reminder of the complexities involved. What are your thoughts on this case? How should the legal and asylum systems handle situations like this? Join the discussion in the comments below. If you found this breakdown informative, please like this video and subscribe for more in-depth analysis of the stories shaping our world. Thanks for watching.